Welcome to lecture number 4 of the series of lectures on practical skills for social justice advocates. My name is David Lepofsky. I'm a visiting professor of disability rights at the Faculty of Law at the University of Ottawa. What's our topic for today? What do you put in your list of demands? What do you go for? You'd think as a social justice advocate, you know that from the start, but it's a much more nuanced question. Up to now, we've talked about how to determine what platform you're speaking from, how to build common ground, and some basic strategic ideas around that. But now let's dive into the substantive, what do you ask for? First thing I want to suggest to you is don't necessarily assume that the community group or coalition that you are connected with, that their first ask is actually what you should be going after. Not unusual for a group to decide that what they want to go for is a new law. Maybe you don't need a new law. Maybe there's something far less than a new law that you could go for. They may come to you and say, hey, let's bring a test case. They want to go to court. They're mad at something the government is doing or not doing, and they figure, let's get a judge to set it straight. May seem intuitively sensitive to people who haven't done test cases before, but it may not be the wisest choice. The social justice advocate's role includes helping your constituency figure out what it is they want to go for. It may be that you don't actually decide in any detail right up off the top, or it may be that you select a couple of options but don't tie yourself to either one. That depends on the chemistry of your group and the political environment you're working in and the tactical advantages of each. On top of everything else, it is really important to make sure that whatever you are going for can't or doesn't boomerang against you, doesn't come back to bite you, doesn't come back to hurt your group. Let's talk about that in great detail as we go through the process for doing this. So what are the principles I apply when I'm going through this exercise in an advocacy initiative? First thing is, whatever we go for has to be legal. And I don't mean just that it has to be not criminal. It's got to be something which can be done. The second consideration I have is, well, if it's legal, I want to make sure it's effective, that it actually achieves our goal or moves us forward towards that goal as effectively as we can. Third consideration is I want a goal or I want an agenda which people can rally around, which will motivate folks in the constituency to fight for it, and others who haven't yet come forward to see this is worth fighting for and get engaged in the advocacy effort. Next criterion I use, well, I'm of two minds about it. It's achievable. On the one hand, it might make sense. Let's not ask for something that we just can't ever get. And I get that kind of reasoning. I've done the exact opposite. I've been involved with others in the fight in 1980 to get an amendment to the proposed Charter of Rights in Canada to include people with disabilities in the protection of equality. Objectively, what we were going after looked impossible to get. That's why when I wrote a memoir about it, I called it Swimming Up Niagara Falls, because we were trying to do something that looked a heck of a lot like trying to swim up Niagara Falls. In 1994, when a small group of us got together and formed a coalition, then unnamed, but it became the Ontarians with Disabilities Act Committee to fight for Disability Act in Ontario, it looked objectively impossible as well. Disability community mostly hadn't heard anything about the whole thing, about the idea. People weren't necessarily jumping on board. There was no pre-existing movement for it. And we were heading into a political era where government was, let's just say, not super receptive. but we won it. It took 10 years, but we won it. I don't give up on a goal or rule it out simply because it's not achievable. I look at it in light of all of the other criteria that I balance. Um, but I also look, if it's going to be a long range goal that's going to be tough to get, I want to see if there are along the road to that objective some interim benefits that we could fight for that will help achieve that bigger objective and that will meet all these other criteria. It'll be effective, it'll be legal, it'll be helpful for my constituency, it'll make things better. I also want to make sure that whatever we propose does not have any harmful side effects. Let me take a moment about this. I mentioned this before, the boomerang thing. There are certain things that a community group might think is really worth fighting for. An expression in the disability rights movement for years has been nothing about us without us. When a government comes forward and says, oh, well, we're proposing a bill, it may not include much, but we're going to then consult you extensively on it, I'm a little cautious. Not because consulting the disability community is a bad idea, but sometimes it can be used as a technique for diffusing activism. We saw this in Canada in 2022, 2023. The federal government proposed a Canada disability benefit, but introduced legislation, Bill C-22, which was extremely weak. It didn't say how much the benefit was. It didn't say whether it would be assured, whether it could ever be cut. It left everything to cabinet to decide later. A number of us were worried that something so vague was not much of a guarantee of anything at all. The government's response was to say, oh, but we will consult the disability community on the regulations. We're committed to nothing about us without us. They, in my view, weaponized a slogan from the disability community and used it to diffuse pressure for changes to the bill to strengthen it. And some disability community groups actually believed that that was a worthwhile thing to accept. I didn't, and a number of groups that I and my coalition were associated with didn't accept it, but it became a big issue. And to me, I now view skeptically when governments try to use a slogan of ours, in a sense, in a way that might undermine our efforts. So it's really important to think about what government's proposing, and it may sound good, but does it have the potential to work against us? I am in formulating or working with a community group to formulate goals. I am not in too much of a rush to formulate the specific asks that we present. On the one hand, if you got specific asks and they're really appealing and really compelling and really obvious, you might want to jump on that fast, but I want to maintain flexibility. I want to be able to fine-tune our objectives as we go, if we could do that. I also don't want concrete asks that might scare off a decision maker before we even get started. To that end, I try to agree on common ground that we could negotiate for as general commitments and then work on the details. That's one way of approaching it. Not always, but at times. For that very reason, I do not ever start by drafting a bill. Even if we know we want a new law, I don't come forward and I don't encourage anyone else to sit down and spend the time to write a bill and then maybe get an opposition member to introduce it. I will talk in a later lecture about the use of private members' bills by opposition members. They can have their use, but if I don't use the bill itself as the model of legislation I expect I want to pass. Why is that? Well, it brings together these various principles, but it also has several other tactical underpinnings to my strategy. And that's this. Number one, writing a bill is an enormous project. In government, they don't just say, hey, let's pass a bill. First, they decide on a policy issue. Then they agree on what measures it should include. Then they agree on the details. Then they instruct someone to write the bill. You would have to yourselves and within your constituency do all that policy heavy lifting at the start before you sit down and try to write the bill. Then you need to apply a very specific legal expertise that the lawyers have who write a bill. Most lawyers don't have that. I don't. There's an office of legislative counsel in most, if not all, legislatures and parliaments, and they're lawyers who have this specialty training. If you don't have that specialty training, you could end up writing a bill that's got all sorts of technical problems, not ones you intended, but just because you didn't have the skill set. And they can become a distraction. A government that's not sympathetic could look at your bill, find some totally minor technical error in it, and make that the agenda. Oh, this bill's unacceptable because it has this one little thing in it we don't like, and blow it up. I don't want to give them a chance for those distractions. So I don't like drafting a bill because it's too much work, it's too hard, it comes too early in the advocacy process, and it could be turned against us. So if you take these principles, the kind of do's and don'ts that I bear in mind, what do? Well, the next important step after you sort of have come this far is a legal question. So if you're a lawyer, of course, you can do this legal work. If you're not, if you're a community group that doesn't have a lawyer advising you, this is the kind of area where you might want to seek legal expertise to advise you. You need to learn about the legal landscape that applies to the area you want to do advocacy in. You've got to ascertain which level of government within Canada or any other federal system has the constitutional power to address this. If you go to the wrong government, they're just going to say, hey, we think you got a great idea. It's just we got no authority over it. We had a very high visibility illustration of this all over the news during the COVID pandemic. There were some people who were vehemently against having a requirement to get a COVID vaccine. And they organized, and a bunch of them were truckers, and they organized and did a big, widely publicized truck convoy to Ottawa, to the capital of Canada, and had a big showy event there. The problem is they'd gone to the wrong level of government. The federal government was basically not the body that was imposing COVID vaccine mandates. It was provincial governments. So it got a lot of attention, but they were going in the wrong direction, among other things. The question which level of government you go to is a constitutional question. So you need to get advice from someone who has some enough of an understanding of the constitutional division of powers between the federal and the provincial government. Then you want to find out if there is a particular part within the government that you are dealing with that has authority over this. If it's education, it's in schools, it's probably the Ministry of Education. But those kinds of mandates aren't just something you get from headlines. You've actually got to look to legislation to see who is assigned responsibility over this area. If you want to advocate, you want to know who the right person is to advocate to. You want to find out if there is any law on the subject that you are going to be advocating on. Not just to see if there's any pre-existing right, whether what you want is already guaranteed, but if it isn't, if there's any legal landscape within which that right might fit. Of course, if there is a legal right already guaranteed, you may not need legislation at all. You may need efforts just to getting that right implemented, or you may need legislation to force its implementation. These are all legal questions. And when you are looking to see what the legal landscape is in the area you're dealing with, you don't just look at legislation enacted by a provincial legislature or the federal parliament. You also have to look at regulations. Regulations are delegated legislation. It's where, for example, if the Education Act in Ontario delegates to the Ontario Cabinet or to a minister the authority to make regulations in certain areas to provide further specificity, then that cabinet or minister can enact those regulations without going to the legislature at all. And if the matter that you want to seek guarantees on or some new initiative on is already empowered by regulations, or if the regulations give someone else the power to do it, they form a very important part of the legal landscape that you need to understand before you pick out the recommendations or the options for your constituency to consider. Now, when I say this is all a legal question, it's actually not just a legal question. It's a legal question plus, because they don't say this publicly, but governments pass kind of two kinds of laws. They don't announce this. There are laws they pass that they really mean to implement, and there are laws that they pass that are kind of performative for their own voting base or whatever. We did X. You see, we passed this law, but they actually, it may even have enforcement requirements, but they never really meant to enforce it, or they never really appropriated funding to provide for its enforcement, or they never really put in place enough staff to enforce it. That's not something you gain from reading the legislation. That's a further investigation you've got to do beyond the actual face of the legislation. As part of all of this, I mentioned enforcement. You've got to look at if there are any rights or avenues that you could harness that could be used to your advantage under existing laws. Most people think, well, let's go to court. Lay people do, but you need to be more specific. There needs to be something you can in law that you can take them to court over. But there also may be other avenues. There may be under legislation some administrative tribunal or other regulatory process that you can take them to in order to advance your issue. Now, that might be specifics, like something established under the Education Act, if we're talking about education for students with disabilities, or it might be a general anti-discrimination claim brought under the Ontario Human Rights Code to the Human Rights Tribunal. Now, I'll talk about test case litigation a little later, but you need to identify which enforcement, at this stage, which enforcement options are available, and you need to figure out which of those is most likely to be effective and timely, because some can take ridiculous amount of time or it be extremely expensive to use, and others may less so. Now, whenever I talk here about reviewing the legal landscape, it's not just a matter of reading the legislation and looking at the kind of the political context of whether it was meant to be politically intended to be implemented or not. There are two other bodies of law that you need to apply. I'm not going to review the details of them here. They're huge subjects. But one body of law is the principles of statutory interpretation. There is an entire bundle of legal principles that go into or apply to how we interpret a statute or a regulation. That blob or body of legal principles is a combination of common law, case law principles, and some statutory requirements. Some provinces or federal government may have a legislation act or an interpretation act which codifies some of the principles that apply. You need to have those principles in mind if you are interpreting a statute, because they literally guide what words may mean. As well, there is a second body of law we need to apply, or blob of legal principles, and those are the principles of administrative law. For law students or lawyers watching this, or law students watching this in any event, if you haven't taken a course yet in administrative law, you should, if you want to do work in this area. It is the collection of non-constitutional legal principles that govern what government bodies, agencies, commissions, tribunals can do. And that body of law includes both common law principles and some statute law principles, principles that are requirements that are established by statute law. So that, just as one illustration, let's say you're reading a statute and it says the X or Y commission, board, minister, whatever, may do X after holding a hearing. Well, that doesn't say what the hearing has to include, but there is a separate statute in Ontario called the Statutory Powers Procedure Act, or SPPA, and it provides in detail requirements that apply whenever a law says after holding a hearing, except if that law exempts the SPPA. So you need to have in mind both the principles of statutory interpretation and the principles of administrative law when you're reading legislation in this area. For example, when you look at all of this in the school context, you might find out that there's something your constituency wants, but that it is delegated to individual school boards. Ontario has 72 of those school boards at the time I'm recording this, and it may be that the school boards are actually empowered to do what you want, but only in their particular area of the province. So that requires you, as you're formulating options, to decide whether you want to go for something that is local at the school board using that authority that you found in legislation, but that will only apply to one area, or you want to see if you can get something done on a provincial level, if you can find a legal mandate for that, which would apply to all school boards. Now, after you've figured out this legal landscape, what's the next step? Well, from here, we've got to actually extract the potential options for our constituency to consider. Now, the unfortunate reality is that the way legislation is drafted and regulations are drafted, they do not make this easy to find. Let's say you have a statute that creates some power in government to deal with some issue, whether it's social assistance or education or barrier removal in the disability context or whatever it may be. That law, that legislation, and its regulations together will invariably or should invariably include certain ingredients. It should set out the substantive rights or duties that are created under it, either rights that individuals have or duties that some public official has. They should set out the exceptions or exemptions where those duties and rights don't apply. They should define who has the duty. It's not just saying government shall. They should, and we hope, tell us who has the duty and who enjoys the right. If there is some bureaucracy that needs to be created, then the legislation may establish the bureaucracy, the department, or whatever that needs to be implementing that and list its powers. Then, if there are any decisions to be made over individual claims or individual entitlements or duties, this legislation and regulations should or could or hopefully does provide map out the legal criteria for making decisions in individual cases. The legislation can also, this isn't necessary, but provide that there is some precondition to someone enjoying a right or the government taking some action. If that precondition isn't met, you don't have the right, the government can't take the action. You got to read the legislation to see if that's prescribed somewhere or if there are none. The final couple of things that the legislation may do is set out a process for enforcing or implementing whatever right or opportunity or benefit you're looking to deal with, and what the remedies are. Now, when you read the legislation and you apply those principles of statutory interpretation and you apply administrative law principles, there's only one tiny little problem you're going to run into, and it's incredibly frustrating. Legislation is not written to make it easy to figure this out. It would be lovely if there were headings in the legislation with each of the categories of provision that I just said. Part one, who's entitled? Part two, who has to do it? It's not written that way. Legislative drafters use other criteria that I dare say I don't understand for figuring out how to describe, how to create some new regulatory scheme or requirement or whatever it may be. It's our challenge to read the law sometimes over and over and over to come up in our own mind with some kind of user's guide that answers those questions. And sometimes you end up frustrated because some of the questions may just not be answered. Once you have this legal structure, the next step you need to engage in is to figure out the informal structure. What do I mean by that? Well, I'm going to talk more about this in a future lecture, but as a general observation, there's the regime that's supposed to exist according to the legislation within the government or wherever, the municipality, the school board. And then there's what they really do. And sometimes they are the same, sometimes they are very different, sometimes they are contradictory. I'll give you just one example. I wanted to, totally not related to social justice advocacy and totally not related to disability rights advocacy. My wife and I wanted to put an addition on our house. We needed to get a variance from a municipal city committee created under provincial legislation called the Committee of Adjustments because it was not consistent with local zoning bylaws. People do this all the time. You go before this Committee of Adjustments and you argue your case. But here's the thing. Core administrative law principles provide that we have a right to be heard, and they cannot artificially just say, you must make your presentation within 5 minutes. But that's exactly what they did. They have a rule. They got to line up with people. They say, you got 5 minutes. Now, you can run off to court, use administrative law principles, seek judicial review and all that stuff. But guess what? That costs a huge amount of money and would have delayed things by at least a year. If it got appealed, a couple of years. Who needs it? Not only that, they're supposed to disclose to you basic administrative law principles, whatever's in their file that the committee members are considering. Well, there were some filings from somebody else in the neighborhood. They never told us about it. They never disclosed it. However, I had a planner who knew about it, went and got a copy of it, and I got to read it. Again, basic, what in law is referred to as the duty of fairness. In American speak, due process, and they don't do it. There is a huge gap between the practical law or practice that they use, the informal process, and what the law requires. You need to investigate both. If we just do social justice advocacy on the basis of what we think the legal structure formally is, but not the reality of what goes on, we're going to miss the mark. Let me talk about test cases. In any social justice advocacy, you may consider, if there is a legal right, either a concrete one or a basis for arguing it's contrary to an anti-discrimination law like the Human Rights Code, or a constitutional guarantee like the guarantee in Canada's Charter of Equality Rights to people with disabilities, you may want to consider bringing a test case. As I said earlier, some people, lay people, will intuitively be attracted to that very quickly, partly because they've seen media coverage of people fighting test cases, and partly because it just seems like if you're getting nowhere with government, Why not go to a judge? Um, I don't run to that place, to that option very often. I've done a couple of test cases in my own name with the assistance of pro bono counsel, so I know what's involved. I'll talk more about my approach shortly, but I've got real reluctance to try to solve a major issue this way, except in a narrow bandwidth of circumstances. Now, I'm not saying to anyone watching this, don't ever do it, don't ever consider it. I'm just telling you my reasoning. And I'm heartened that there can be alternative ways to approach this beyond the traditional test case. But here's my reluctance. First, it takes years. You're going to bring a test case. You've got to try to establish some new right, some new entitlement, whatever. You better be ready for the fact it's going to take years. When I fought my case that I guess I'm most connected to my name, to force the Toronto Transit Commission, Canada's largest public transit authority, to announce subway stops allowed for blind people and later bus and streetcar stops, from the time I first raised it to the time I got my final ruling was over a decade, from 1994 to 2007. It takes a ton of work. You can't predict how much work it's going to take, but you have to assume that the other side is going to mount major legal firepower against you. In the biggest example I can illustrate, the Toronto Transit Commission case, when I won the second case, I brought a Freedom of Information request to get their legal bills. And I found out they spent $450,000 of the taxpayers' money on lawyers to oppose me. That's not to say everybody's going to fight like that, but it is illustrative of what you could face. And organizations, especially if it's in government, they have staff lawyers that they can hire, or they can retain outside counsel. Another risk with a test case is, depending on where and how you're litigating it, you could be exposed, your constituency, to having to pay the legal costs of the other side if you lose. In court cases, that's the case. In a case before the Ontario Human Rights Tribunal, that's not the case, but that's not the end of the risk in terms of cost. Yes, you could bring a complaint before the Human Rights Tribunal and even win, but if you lose, no, the tribunal can't order you to pay the other side's costs. But if you go to that tribunal and you win at the tribunal, and the other side then takes the matter before court by an application for judicial review, and if they win the judicial review application, you can be exposed to pay their legal costs for the court application. Let's say you were right all along at the tribunal, but the tribunal messed up its reasons. And the court says, well, the tribunal was wrong in its reasoning, and we're overturning it, or maybe sending it back or whatever. You're on the hook for their mistake and the legal consequences. When you get involved in these proceedings, there are often disclosure obligations, and that is, believe me, a ton of work to make sure you have disclosed everything that is relevant from your side, and to review the disclosure that the other side provides, or to fight to make them disclose all that they should have to disclose. There's another reason beyond the workload and the cost risks that make me very cautious about a test case option. What happens if you're dealing with an issue with the government and advocating on it, and then you bring a test case? What does the minister do? Well, the government's typical response is to say, oh, we can't comment on this because it's before the courts. Frankly, in my view, that is a bogus excuse. These cases don't typically go to a jury. They can comment all they want without violating any principles that relate to the case. But in any event, they use that bogus excuse quite regularly, and I think quite happily. See, if you're a cabinet minister, you tend to be in a portfolio, I'm going to make up numbers, for maybe 2 years. Some are longer, some are shorter. But somebody brings a lawsuit over a hot potato issue. You are given an easy out. You can say, hey, this is before the courts. I don't have to deal with it. I don't have to comment on it. I could just say, we will deal with the court proceedings. And then, you knowing that you're likely not going to be there in 2 years, the hot potato becomes somebody else's issue. So it can actually freeze efforts at progress. Not always, but it's a serious, serious risk. It becomes an incredible pretext for government doing nothing in some area that you want them to do more in. Also, court proceedings tend to be high risk. They're win or lose. If you lose, you seriously lose. And if you go to court and say the government has a duty to provide X to these children, and the court ends up ruling no, they don't have that duty, you will find government saying, well, the court ruled that we needn't do this, and use an excuse for not doing it. The court never said you mustn't do this to the government, but governments sometimes will use the court ruling, overinflating it as an ongoing excuse for doing nothing. Now, that kind of government response, is it always? I can't say that, but it is a risk, and it's problematic. What if you win? If you win, there can be appeals. And if there are appeals, that's more cost, more delay, and the victory at trial could be overturned on appeal. So when do I use test cases? Now, this is just me. And I'm not in any way trying to persuade others that this should be the only approach they use. I respect whatever approach people choose. I'm just raising my concerns. I bring a test case when I think our case is not going to be, is overwhelming. In other words, where I'm actually not making new law or trying to. There are major test cases that have come forward over the years in other areas. R versus the Morgentaler in the 1980s, overturning Canada's criminal restrictions on abortion proceedings, cases in the 90s that established the right of same-sex couples to marry. These are major landmark court decisions that changed the face of practice in important areas for those advocating for those reforms. And they really did make new law. I don't look to make new law. I'm not afraid to. But when I fought the Toronto Transit Commission to audibly announce route stops, I had a case which, in my view, was an overwhelming one on the facts and the law. I was just trying to get them to obey the law. And in that context, and I may push the envelope of law in some of the test cases I move in, but in any event, I limit myself to that, and I do so for tactical reasons. Even then, I'm in it for the long haul. And if I were to lose a case like TTC, it would have been emblematic proof that there is a serious systemic failure, not only in their route stop announcements, but in our human rights enforcement process, which would itself become a platform for reform advocacy. Let me give you another illustration, and it's one I did during the pandemic. And it was one that was actually remarkably short. In Ontario, we have socialized health insurance. You get a health card, it's valid for 5 years. When you go to the doctor, you just present the health card, and that is what ensures that you are insured and don't have to pay. Has to be renewed every 5 years. When the pandemic began during COVID, the government said, we don't want people having to go to a Service Ontario office to renew their health card because we've got this pandemic happening. There are no vaccines. We don't want people spreading the disease. They closed their Service Ontario offices generally, as I recall. And what they did for patients, they said, if your health card expires, That's fine. Just keep going to the doctor and we'll treat it as valid. Mine expired in June of 2020, and I kept going to the doctor, and it was fine. Well, a year and a bit later, after vaccines came out and so on, government said, well, we are going to provide you've got to now renew your expired health cards, but we'll give you 6 months. They gave till the end of February of 2022. And yet, and otherwise, you got to go to Service Ontario and renew your health card if you want to keep getting health coverage. Now, I didn't want to have to go to Service Ontario because of the pandemic. It was we had vaccines, but there was still exposure. So what happened? It happened that they did provide an opportunity to renew your health card online, which is great. So you don't have to go into Service Ontario depots in person. However, you could only renew it online if you had a valid driver's license. I'm blind. They don't want to give me a driver's license. So I had to decide what to do about this. I tried raising this with senior government officials. They all agreed they needed to fix this. It's a neutral requirement, applies to all, but it's systemically discriminatory against blind people and so on. And so I said they should, and what made this worse is Ontario has copied from what they do in a number of US states, a non-driver's photo ID. And I have one. It is government issued. It works as government ID. And I said, hey, if you issue the driver's license, you recognize that as valid government ID to renew your health card online. Why not your own provincially issued non-driver's photo ID? Again, they didn't do it, but they said, no, senior government officials said they had no reason, no justification for what they were doing. Well, by the end of late January 2022, the government had not backed down. They had not fixed it. So I brought a test case with the assistance of pro bono counsel. I decided not to go to the Human Rights Tribunal because it would have had months of delay, by which time the case would have been moot. I needed a decision right away. So with the assistance of pro bono counsel, I filed a judicial review application claiming that the requirement of a driver's license, but not accepting the photo ID, government photo ID, to renew your health card online was discriminatory, contrary to the Charter of Rights, guarantee of equality of people with disabilities. And the government caved within 2 weeks. And they simply issued a news release giving us what we wanted, what I wanted. And so this never went to a hearing. Now, there was no difference in what they knew from before I brought the lawsuit and after. It's just the lawsuit forced them to either be coming to court and having to answer what was unanswerable in the middle of the pandemic, or they had to fix it. That's my own formula. There is another approach to test cases beyond the traditional one that led to major wins, like the Morgentaler case and the same-sex marriage case, same-sex couple marriage case. And it's developed by a friend of mine named Lainey Feingold, who's a disability rights lawyer in California. And I strongly encourage you to read her book, Structured Negotiations, a winning alternative to lawsuits. Lainey, Lainey, Feingold, Feingold. In a paragraph, instead of going to court, she offers an organization where she's got a systemic disability barrier, the opportunity to engage in an out-of-court negotiation process that she calls structured negotiations. Her client doesn't waive the option of going to court, but they try to negotiate a solution to a disability barrier, not by lawyers meeting lawyers, but by her facilitating clients meeting clients. It may be an objection to the technology or the non-staffed checkout technology at a store. Well, she'll bring in blind clients to show their customer service people why blind people can't use that technology and demonstrate technology that could solve it. And if they're successful over a process, they end up negotiating a settlement. And typically, and you can go to her website, lflegal.com, and you can read these settlements. They're public, they're not confidential, and they're very collaborative. It's a very collaborative dispute resolution process that she and colleagues innovated under her leadership, and I strongly recommend it. Now, let me move on to, if we're not including a test case, if we're not going to pursue a test case, how do we come up with our alternatives that we can consider within the legal landscape that we figured out? There's a few tips I'm going to offer. One is that you get together people who either within your constituency or some experts in the field or both, and just brainstorm. Find out what's been tried elsewhere. If you can find examples of things done elsewhere that have worked, that is a really compelling thing to push for in your own community. I then take the ideas that come out, and it's very useful to develop some kind of options paper. Now, this is something that governments can do internally when they're looking at policy things. When cabinet is going to decide on a major new legislation or whatever, they get what's called a cabinet submission. It's confidential, we don't get to see it. But it will give some of the options. It'll say what the social problem is. It'll list the options and recommend one of them. And while listing the options, it'll give the pros and cons of each. That's what an options paper would be. I will, in connection with this lecture, provide a link to an options paper that I developed working together with a phenomenal team, collaboratively, of law professors then at the University of Toronto. When the Ontario government had, the Ontario public had elected a new premier, Dalton McGuinty, in 2003, who was prepared to deliver a Disabilities Act with effective enforcement, they turned to us and said, well, what enforcement do you want? So we got together, myself and these law professors, and we brainstormed by looking at different regulatory schemes, what options there might be. And we produced an options paper, made it public to our supporters, and used it as a basis for advocacy. Again, in assessing these options, I used the kind of criteria I offered you earlier about what's the most effective, what's the least likely to trigger distractions or boomerang effects, and so on. And in developing options and an options paper, one option I always suggest that we put on the table whenever we can is the option of trial and error. When you come forward to any government or school board or whatever with a new initiative, people and organizations sadly can be very reluctant to implement something new. It's just part of the institutional reality, unfortunately. And bureaucrats or politicians can, at times, not all of them, but can end up spending a whole lot of time doing what if. And to deflect, distract, delay, get rid of that kind of response, it's helpful to offer the option of trial and error. Hey, why don't we try this at one school or two schools and see how it works? And if it works, then we can resume discussing whether it could be used more system-wide. This has huge advantages. For the one thing, it's way easier to get going. It's just one or two schools. For a second thing, it's not a big cost thing typically because you're not trying to do it system-wide. Third thing is the nervous Nelly bureaucratic reaction can at least be muted some. But finally, if it works in those couple of schools where you try it, you have a new natural ally. You've got the parents of the kids at that school, you got the teachers in that school and other educational staff, and you got the principal. And if they say, hey, we did it, it really works, that could be viewed as persuasively as you, or more persuasively than you as a social justice advocate, advocating it from the outside. When you're doing this options paper and applying these options, it's important not to bargain against yourself. Nobody in a negotiation in a traditional case wants to be in the position of coming forward and saying, well, how about X dollars? And the other side says, no. Okay, well, what about X minus 10%? And what about X minus 20%? Where you're just literally, the other side's just going, no, no, no. You are bargaining against yourself. My view when I'm looking at designing options is I don't want to bargain against myself in the devising of those options. If there's something we need it. We can offer interim steps like the trial and error test case thing, or test demonstration, or try it out in a few schools thing. But I don't want to bargain. When I say bargain against myself, I don't want to drop my asks below what we really need before we even start a discussion. If the government ends up not adopting it, let them take the heat for that. I don't want them to say, well, that's all we were asked for, because they'll use us as the excuse for under-delivering and under-serving. In an options paper, it is good to show that each of the options are legal. It is worthwhile to show whether a particular option needs legislative amendment or needs the amendment of regulations or a new regulation. Are there any legal barriers we've got to remove to those options being adopted? And then show the pros and cons of them in terms of how effectively they'll work and so on. When I engage in this kind of advocacy, when I'm developing options, I think it's important to take a bit of a nuanced approach to law. What do I mean by that? My goal when I'm devising an option, a measure, is, as is any social justice advocate's goal, is achieving a social change that we want. So I look not only at the provision that I'm proposing or the measure I'm proposing from the point of view of, is it legally enforceable and all that kind of stuff, but what actually changes people's behavior. I wish I knew the answer to that. It's not a legal question, it's a question of human psychology, but it is front and mind in pretty much all the advocacy I've done for over 3 decades. And I'm still learning. One of the aspects of human behavior that was very informative for me, or one of the features about the context, is this. When we draft, if we're drafting a legal requirement as lawyers, or community groups are, they're thinking about, well, what does the law require of this person? But the reality is most public officials, most community group members, most obligated organizations do not get legal advice on most of these questions most of the time. I firmly believe that in the world in which we live, most people who are using legislation are actually non-lawyers. So I like to word things in a way that will say what we want to say in a way that actually will affect and change the behavior of lay human beings. And that is not the way legislative drafters work. Let me give you an example. And this is one where I've actually met some within the disability rights movement who take a different approach. When it comes to defining disability in legislation, my view is make it open-ended so it covers all disabilities, but name all the disabilities you can that you want it to cover. And now, why does that help? It means that it's because somebody who is a business owner or a human resources manager, they look at it, and if they see that autism or ADHD or whatever is covered, they'll know it. They don't have to call a lawyer. They don't have to guess. If a community group member is seeking something from them, and they have that disability, they can say, maybe an employee, whatever, they can say, look, I have this disability, and here you'll see right here in the regulation, it says that that's a disability for the purposes of this act. And so you don't have to rush off the lawyers. It avoids any risk of there being, well, I don't see it here, so we don't, unless a court tells me we have to, then we don't, you get around that. What was the argument against this when it came to wording the definition of disability in the Accessible Canada Act? And we weren't successful in this advocacy effort. The government said that they wanted to use a sort of broad principled one that was respectful of the social model of disability. What am I talking about? The social model of the old view of the world of people with disabilities based on the medical model was your disability is a biomedical condition and it's part of you, and that's the problem. That's the source of the problem. The social model says, no, no, no. What disables us is the environment we're in. Now, I get that, and there's real power for that, and that makes sense, and it's a good shift in advocacy focus and understanding the world, and I've echoed it myself. But it is, to me, not a tool for writing legislation, because I view this legislation as a tool to achieve a change in human behavior, and my debates or others' analyses of social versus medical model is not going to change their behavior as much as it would be if they just spell out the names of the disabilities. And so I'm a result-oriented guy, and that's the result I'm trying to achieve. Whether that's a nuanced approach to law or just a self-evident one, I don't know, maybe I'm overstating its compelling nature, but it matters. So let's talk about writing a brief. There are pretty core ingredients that at least I use when I'm writing a brief. I always start with a summary of what we're complaining about and what we're asking for. I write that last. Next, talk about who we are. Who is our community group? Who do we speak for, or whose interests are we addressing? And what credibility do we have if we've been quoted in the media or in legislation, in parliament or whatever, something to build credibility or authenticity. Next section of the brief is what's the problem? Describe what the issue is that you're trying to address. Next, what are the solutions we're asking for? Why they help? And then I will answer counter arguments. I try to anticipate the arguments that may be made against us, and then I try to refute them. Now, throughout a document, a brief that I write, and this is very much the same as when I'm writing a factum in court, I always have a theme in mind. It will become a headliner for the overall argument, but think of it like a one-liner or a headline, a core theme that I'm trying to weave throughout the document. And I may actually come up with it only partway through the writing, but it is still worth weaving it through. It defines the discussion. It will then define how we take cases, our issue to Parliament. If we go to hearings, we'll talk about that later, or to the media, we'll talk about that later. It should be a theme that convinces governments, pulls in supporters, and attracts media coverage for us. And I think about this because we tend to get pickled when we write these in the details of the brief or later the news release. We got to remember the people who are reading what we write, whether they're politicians or they're public servants we're going to lobby, we'll talk about that later, or the media, we tend to get pickled in all the details of the injustice we're battling. You've got to remember, they're not. We are absorbed in it. They haven't really thought of it much before. So I need my core theme to grab them in a way right off the top And it may become my headline. It may become the title of the brief. There's no rules about what the brief has to include, so it's up to you to decide when and where and how to frame it. My aim when I write a brief is to write it in plain language and to avoid technical terms. If I have to use technical terms, I've got to define them, but I assume my reading doesn't know any of the technical stuff. When I'm working on the core theme, it drives me to that, or that core message. It drives me to that idea of using plain language. I also like my core theme to be totally nonpartisan, to appeal to people from any political persuasion. And of course, I want it to fit in a tweet. So I have a real sense of what short means. Let me give you some examples that I've seen. Shifting from, when I do this, I've already talked in earlier lectures about shifting from the language of discrimination to talking about barriers, and talking about a barrier-free society. I have shifted from talking about people with disabilities are 18% of the public, which 18 doesn't sound too big, to saying 2.9 million Ontarians, or over 8 million Canadians. It's the same people. It sounds bigger. If I'm talking to politicians, I'm going to repeatedly talk about voters with disabilities, because all of a sudden, politicians sit up a little more when you're trying to persuade them about what voters think or what voters need. I've gone even more nuanced than that. When I talk about the Disabilities Act, I used to talk about it having the core objective of achieving a barrier-free society. I now talk about it requires the government to lead us to a barrier-free society. I use that turn of phrase because it infuses into your thinking from right off the top the duty of the government. It's not just the result that's nice, that we all want and we can all agree on, but turns our attention right to what the heck is the government doing. Other kind of themes that I've used at different times or woven in when doing a political advocacy action or delivering a brief during and around the end of October. Will the Disabilities Act be a trick or a treat? Which just gets people thinking about Halloween. My colleagues in the Ontario Autism Coalition, who've done excellent grassroots advocacy, took on a government policy many years ago that limited autism service supports to kids under 5. And their slogan, which became a very powerful argument, self-contained, is autism doesn't end at 5. When we were fighting for the terms of the Canada Disability Benefit Act, I stole that and permuted it. That act was only going to provide benefits to, and does only provide benefits, income supports to people with disabilities of working age. Our slogan, disability poverty doesn't end at 65. That is a theme to weave in, and a point that you make over and over has a lot of power, I believe. We wanted to talk about people with disabilities in terms that I can weave into one of these themes, and that engages everyone. So I talk about them as the minority of everyone. The beauty of this is however you frame your core message, whatever terminology you use or turn of phrase, they help control the debate. They help direct how people talk about your issue. The moment we've gotten government to talk more and more about barriers, they're in our ballpark. Now, let me turn to building the substantive argument. You know what your core message or your core turn of phrases are going to be. How do you build the core argument? What do you address to support what you need? Here are some themes that you can grab onto. How fundamental is the issue? If we're talking about healthcare, or we're talking about education, or battling poverty, show that this is a core issue, or play on the fact, obviously it's known to be a core issue, but play on the fact that it's a central issue in public life. It's not marginal. Or finding a place to live. How many people are affected? Focus on the showing that what you're asking to do would really benefit a lot of people, and that right now, by not acting, the government's hurting a lot of people. Tackle a perception you may have to face that the public may think the problem's already solved. In the area of building buildings that have accessibility barriers, there's a very widespread belief that, oh, new buildings have to be accessible. Isn't that the law? And built environment professionals like architects think, well, isn't the Ontario building code, doesn't that cover it all? I thought it did. So you need to build into your argument a countermeasures to call out that stereotype or perception and to refute it. Showing that there are benefits beyond the disability community, beyond your constituency. So when we're advocating for accessible restaurants or hotels or whatever it may be, talk about the fact that there are 1 billion people with disabilities worldwide. That's a tourist market that we can't afford to lose. Anticipate stereotypes about us. This accessibility is only about buildings and ramps. Well, no, it includes digital accessibility and lots of other kinds of barriers. And that's important to deal with because people then associate accessibility only with, or primarily with building inaccessibility, and then think it's all very expensive to fix. You've got to tackle stereotypes around cost. The deep-rooted stereotype out there is that doing things for accommodating people with disabilities is just always a very expensive thing. Not only talking about cost of not doing it is important, but side benefits is very important. Every time you have a accessible entrance to a restaurant, that enables the restaurant to benefit from not only customers with disabilities, but their family and friends and people with shopping carts or baby strollers or whatever. But also answer the substantive answer on costs. Show that the costs for addressing the needs of people with disabilities in the area you like to address are overblown and are overstated. When it comes to accessible housing, show that there are very limited costs necessary to build accessibility into new housing, and that if we had a proactive strategy of ensuring new housing is built to be accessible, that we would then be able to counteract or at least reduce the accessible housing crisis that we're facing in society. Again, as I mentioned earlier, it's very helpful to point to, in your argument, to where your proposed actions are being done elsewhere. Show that your jurisdiction is behind the times, that others are doing it better, and the advantage of doing that through hyperlinks or contacts is that it can give public policy people they can contact, so they can themselves find out that, hey, this works, it's doable. We had all the same reservations you do, but it turned out it worked out just fine, and worked out better than anybody thought. You need to be ready to answer the question of it's not the right time. As I mentioned in an early lecture, I believe, I've been told it's not the right time at any time. Whether economy is good or bad, there's always some argument it's not the right time. I blow through those arguments. I just carry on and say, look, we can't afford not to do it. And the cost of not acting now is that more barriers will be created later, and it will be more costly to fix it. So you are creating future costs by not acting, whatever the state of the world is right now. It's very helpful in a brief or a submission or a presentation or substantive argument, if you can, to give concrete illustrations of people who are hurt by the status quo, whether you can do it by name or if you do it by just description but without a name. But in any of these kind of discussions, people become more alive and are more energized if you're trying to persuade them when you can point them to real live examples. Could be newspaper stories. In any kind of advocacy writing, I'm looking for quotes from the government itself, either their platform or policy statements they made or statements they made in answers to questions that are put to them in the legislature, whatever, or news releases by government. If you can tie what you're proposing to values they say they're committed to or specific policy objectives, they may have said them in other contexts, but if they can fairly be used in your context, they are very helpful. I've emphasized before, over and over, the importance of being nonpartisan. I want to make that clear in whatever brief I submit, in whatever written submissions I make. And I also want to make it clear that we are always ready to work with government. Even if it's a government we've been highly critical of, we always, wherever we can, extend the hand to work together. Finally, let me just talk about the weight of certain arguments that will naturally appeal to some. Some will think, well, why don't we map out legal arguments under the Charter of Rights or the Human Rights Code or international covenants like the Convention on the Rights of People with Disabilities? I got nothing against using those arguments. Absolutely nothing against it. And if they got them, certainly map them out. But I don't stop there. I think of them as additions that are worth adding for rhetorical benefit, but in terms of, and of course, if you can show that what they're doing violates a court ruling, that of course is very important. But I don't expect or operate on the premise that political decision makers or bureaucrats are going to be moved by that. If they are, great. In other words, I'd include it, but I would not assume that we stop there. Well, with that, if we have some kind of agenda in hand of what we want to get, let's turn in our next lecture to what's in the advocate's toolkit for getting it.